Hello, I'm Amanda Reedling with the Georgia Wills Trust and Probate Firm in Marietta, Georgia. And today I want to give some tips on how to avoid probate for some or all of your assets upon your passing. So the first sort of easiest way is use of beneficiary designations directly on accounts. A lot of people don't realize you can actually put beneficiaries on checking accounts, savings accounts, brokerage accounts, stock accounts, bonds, all sorts of things. So it's not just for retirement accounts and it's not just for life insurance. The only way, in my opinion, though, to use them responsibly is to make sure if you're naming a direct beneficiary on an account, that person is an adult and that person would not be harmed somehow by receiving those assets. So you want to make sure that you don't list any minor beneficiaries. I made a video specifically on why that's a bad idea and the negatives to conservatorships. So feel free to go watch that one for more information about avoiding that for minors. Also, if you have a beneficiary that's special needs and inheriting from you may kick them off any benefits that they otherwise would qualify for, you want to make sure you're not doing that too. So just because it lets you put a beneficiary doesn't necessarily mean, based on your wishes and who you want to inherit from you, that it's a good idea. But it is a tool that if you put a beneficiary on that, it does avoid probate. It passes directly to that person by operation of that designation. Another way to avoid probate is with use of joint tenancy with rights of survivorship. So this is joint ownership of assets. Now, there's two ways to own property jointly in Georgia. One means that if one of you passes, the other automatically inherits it. That is what I mentioned. It's called rights of survivorship. The other way is called tenants in common, which is everything else. So if it doesn't say rights of survivorship, then it's tenants in common. If it's tenants in common, then that means if you pass away, your half of that asset still requires probate. This is why it's very important to look at any deeds to real estate that you own jointly with someone. Make sure you have the kind you want. If you want it to avoid probate and go directly to the other joint owner, make sure it has that language on there with rights of survivorship. If you don't want the other owner to inherit 100% of your interest in that property, then you want to put your half of the property into what's called a revocable living trust, and that's how you avoid probate for that half. Otherwise, there's no other option. Beneficiary deeds are not something that is allowed in Georgia, so you either have it with rights of survivorship or you put it into a revocable living trust. A revocable living trust is also the tool that you would use, in my opinion, again, responsibly, to avoid probate for all the rest of assets that you either want to benefit minors, that you maybe want to benefit any special needs beneficiaries, or other beneficiaries that would otherwise be harmed by inheriting from you. A trust is a document that is outside of your will. It reads and feels just like a will to you. It says who gets what and when and who's in charge. And then, but it has its own separate set of laws. It is a two-step process to use. So you not only create the trust and sign it with all the valid numbers of signatures and witnesses and language and all that good stuff, but you then have to take every asset that you want to be governed by that trust, and you have to do something on paper to either put that asset in that trust. For example, with deeds, you would retitle and do a new deed transferring that property into that trust. Same thing with bank accounts, brokerage accounts, all those sorts of things. You can retitle those accounts in the name of the trust, or you can use beneficiary designations to get those assets to that trust. And so anything that's think of a trust as a Tupperware for your assets. So it's a container that you can then put things in. They're already in that container. If you pass away, the trustee you name in that document can immediately step in and go do things with those assets without having to file your will with the probate court and do all the things that are required to get that court order. So I hope you found this helpful. As always, you should not make these choices on your own, and you should not do any drafting of any trust or deeds on your own without a qualified estate planning and probate lawyer. There are lots of pitfalls that you won't realize when you're drafting your own things that you would definitely want to avoid. So always get help with this stuff. But now you know what is out there are as tools to avoid probate if that's something that's important to you. Thanks, everyone. Bye.